Now, without any further delay, let's begin today's event. Again, wellness programs, compliance, and risks. I would like to introduce your first presenter for today, and that is Gary Bossert. Gary, you have the floor.
Great. Thank you very much, Alicia. I appreciate your help today, and I want to welcome those attending to this session. This is the second of what will become a quarterly employment law webinar that the Medical Study Plan is providing to members. So it is an exclusive benefit of membership in the Medical Study Plan, so I appreciate you all attending today. Today's topic is, of course, has already been said, wellness programs, compliance, and risks. Wellness programs are an important part of any employer's benefit program and should be an important part of any employer's benefit program, and something that we strongly support our member practices in strategizing and presenting to employees. We have been working on health promotion programming for many years and continue to invest resources and time and energy in developing and coordinating programs to benefit both you, the practice administrator, your practice, and your employees. Nothing is more important to us than the health of your members, and anything that we can do to help them with chronic conditions, with eating healthy, with feeling good about themselves and the work that they do. In fact, this year we introduced a new employee assistance program, Practice Wellness Personal, which we are very excited to bundle with our benefits, and is just one more example of what we are doing at the plan level to introduce wellness programs to practices. So today's session takes that one step further by saying not just what programs are available, but how to make sure the programs and the strategies that you have in place or are thinking about putting in place, are they compliant with the law, and what are the risks associated with that program. And to do that, we have two presenters on the line. The first is somebody that I think some of you are familiar with already. Jason Hooray serves as the Medical Study Plan's Health Promotion Program Manager. He's been working with the Medical Study Plan for, I think, nearly 7 years now. He holds a BS in Sports Medicine, a Master's in Health Promotion, and is a Certified Health Education Specialist. He's got over a decade of experience in worksite wellness and has worked with hundreds of our practices across the state to strategize about health promotion programming and giving good practical advice on how to implement practice wellness programs in their, for their employees and in their practice. So we welcome Jason to the panel. Second, Ann Murray is a partner at Nelson Mullins Riley & Scarborough in Atlanta. She presented earlier this year in another webinar and will be a regular participant in these employment law presentations going forward. She is a member of her firm's healthcare team, which focuses on providing comprehensive services to hospitals, physician practices, and other healthcare providers. She's a regular speaker and writer on various topics, including the ACA, HIPAA, data breaches, and on-site clinics. So this topic is definitely in her wheelhouse, and we are fortunate to have her as a panelist today. So I want to welcome Ann as well. So having said that, let me turn the presentation over to Jason Hooray, who will begin today's presentation. Thank you, Jason.
Thanks, Gary, and good afternoon, everybody. And again, as Gary mentioned, my job is to really partner with you, the practice administrator, to identify specific short-term actions you can take to really impact your claims in the first year and potentially put in place a long-term strategy to really help control costs over the following 3 years and beyond. But most importantly, creating a practice environment where your staff really wants to come to work and is a place that allows them to live happy and a purposeful life, even while they're at work. So remember, this service that I provide for our member practices is an added value to your practice at no additional charge. So I'm very excited about the webinar today and hope that this session will allow you to understand and uncover the legal landscapes when it comes to implementing or perhaps further enhancing your existing program. So when it comes to improving employee health in today's competitive marketplace, this is really a bottom line issue for many of our practices. Chronic conditions, as you may heard, many that are really exacerbated by weight are on the rise, so adding to the cost of healthcare delivery and lost productivity through disability claims and absenteeism. So let's take a look at some of the stats. So more than 1/3 of Americans are considered overweight and or obese. 117 million Americans had one or more chronic illnesses as of 2012. The top 2 chronic conditions that are driving up employer health care costs are depression and obesity. And we see that, in fact, in the NCMS plan. And the Center for Disease Control and Prevention, the CDC, estimates that almost 86 million Americans have prediabetes. So the North Carolina Medical Society Employee Benefit Plan has long promoted, as Gary mentioned, healthy lifestyle programs and believes that effective wellness programs lead to better lifestyle choices, which in turn lead to better, healthier populations. So as I mentioned here in the slides, wellness programs can have a real significant cost savings for employer health plans. So here's some interesting facts that further support the need to create a culture of wellness at your own individual practices. An individual who walks 30 minutes per day, eats healthy, does not smoke, has a waist size less than half their height, and drinks only in moderation, typically spends 33 to 50% less on health care. More than 60% of employers in a recent survey have said that wellness programs reduce their overall health care spend. And then the third point is that studies show that a well-designed wellness program can yield a return on investment between $1.50 and $3 spent, and this is over a 2 to 9 year time frame. So wellness initiatives have become the norm in most employee benefit programs, including the NCMS Plan's Practice Wellness Program that is perhaps prevalent in your own practice today. In fact, many of our larger medical practices are fully engaged in supporting and creating a culture of wellness and now making strides to infuse wellness, and my job really is to engage and infuse wellness into some of our mid-size and smaller practices. Wellness programs have become really the norm, as I mentioned, and 87% of employers said that they're committed to workplace wellness programs, and 73% of employers really offer a wellness program. But really, do you know that legal rules apply to some of these programs? My friend Ann, who we just became acquainted with just a couple of days ago, is really going to guide us through the legal requirements of wellness programming. So I'm pleased to join and welcome Ann to the phone call today. Ann?
Thanks, Jason. I'm here to talk about what many of you dread sometimes, but the legal requirements that apply to wellness programs. The goal here is certainly not to discourage you from adopting a wellness program. As Jason talked about, you know, it's amazing the benefits and the statistics. You know, now we've got a couple decades of statistics showing the wonderful benefits that a wellness program can achieve, not only for employees, just overall general health and, frankly, happiness, but also for your health plan spend, you know, especially for those folks who, you know, may be in industries where there was a higher incidence of, you know, just diabetes, you know, obesity. A lot of these wellness programs have been shown to really have, you know, really save a lot on costs. So with that in mind, what I want to go through is some of the legal requirements that you want to be thinking about as you run your wellness program. Now, one of the great advantages with NCMS is that, you know, they're operating wellness programs, and those are, you know, there's links to them on the website. and they take that responsibility off of your shoulders. But at the same time, you still need to be aware of what some of these legal requirements are that are out there. You know, can you force people to do some of these wellness programs? You know, is it a carrot or a stick approach that works better? Is one prohibited? What are the different restrictions that apply to you? And especially if you choose to go out on your own, and, you know, for a lot of people, and all of you are in the healthcare industry, you may decide, you know, I want to go operate something myself. Well, in that case, you know, not just because I'm legal counsel, but I would say make sure you've talked with your own legal counsel about what the requirements are and make sure that you're operating it properly. So with that, let's talk about what some of these legal requirements are. The list in front of you on the slide goes through the main federal laws that apply to wellness programs and disease management programs. We've got the Americans with Disabilities Act, ADA, the ADEA, COBRA, pregnancy discrimination that applies to certain types of wellness and disease management programs, HIPAA, which so many of you deal with nowadays. I skipped over ERISA, the Mental Health Parity Act, GINA, which talks about genetic information, and then many of your favorites, the Affordable Care Act. So let's get right into it with the Americans with Disabilities Act. So there's two main rules under the Americans with Disabilities Act that impact wellness programs. The first is the general rule that prohibits employment discrimination against disabled individuals. And then the second rule limits the circumstances under which an employer can require employees to take a physical exam or answer medical questions. So it's this second rule that we really want to focus on, because if you think about a lot of the wellness programs that you're operating, especially let's say a health risk assessment, those involve some type of either physical exams or answering medical questions or both. And the key here is there some sort of disability-related inquiry that's being asked? So what's that mean, a disability-related inquiry? That is any time that you're asking a question or some series of questions that's likely to elicit information about a disability. So for instance, asking some sort of broad question like, what impairments do you have? Well, that's likely to bring up an answer if someone has a disability. Or asking about someone's prior workers' compensation history or what prescription drugs they use. All of those fit into this category of likely to elicit information about a disability. On the other hand, other questions that are more general, asking about an employee's general health. Do they use illegal drugs? Ability to perform job functions. Is there something you believe would impede your ability to perform job functions? Are you able to perform them? Or a non-disability related impairment, let's say someone had a broken arm. How did you break your arm? But any time that you do have these types of disability related inquiries, we're going to need to worry about the Americans with Disabilities Act. In the wellness context, any type of inquiry or medical exam that's part of, like I said earlier, a health risk assessment or what's your medical history is going to be considered this disability-related inquiry or a medical exam. And so we need to always worry about whether or not we are complying with some of the exceptions that are available from these ADA requirements. So let's talk about the biggest exception. The biggest exception to this limit on disability-related inquiries is an employer can conduct medical exams or make disability-related inquiries as part of your wellness or disability management program, as long as you meet a list of requirements, and those are your program needs to be voluntary, and we'll get into kind of what voluntary means in a minute here. You have to have certain confidentiality protections for the information. The information can't be used to discriminate against the employee. I mean, I think that's kind of obvious here. And a required notice has to be provided to the employee. And then coverage under the plan or specific benefits under the plan can't actually be denied if someone refuses to participate in the medical exam or the disability-related inquiry. So as I said, voluntariness is what can really be tricky here. You know, if a penalty applies, generally they view the program as not being voluntary. So under new regulations, there were some new regulations that were issued in 2016 and that took effect in 17, they actually allow employers to offer incentives up to 30% of employee-only coverage and still be considered voluntarily. So, you know, if you are setting up a wellness program and you're going to require these types of medical exams or health risk assessment programs, you need to focus on what are the different levels of incentives, or, you know, are you taking a carrot or a stick approach? Either one here is going to trigger these rules, but you need to be thinking about the 30% limit that the Americans with Disabilities Act imposes. Note, we're going to talk about HIPAA and some special limits that HIPAA imposes later. In particular, we're going to talk about the fact that smoking or tobacco-related programs can impose up to a 50% penalty or incentive, and so just note that's separate from these Americans with Disabilities Act rules. So, end result is, you know, if you're structuring your wellness or disease management program, you need to take care to make sure that qualified individuals with disabilities have equal access to the program benefits. You know, you can't impose greater obligations on them in order to get the same equal benefits. So if you have let's say you have fitness or weight loss program memberships that you're offering, you've got to make sure those locations are accessible to disabled participants. If you've got educational programs or health lines that are online, you know, nowadays so much of these wellness and disease management programs have moved to some of the online risk assessments and educational materials. But what if someone has hearing or sight disabilities, vision disabilities? You know, is there an alternative that's available to them? A lot of those are just questions to ask as you're interviewing wellness or disease management providers, and to make sure that they've addressed that. You know, many times I was just working with someone in the past couple months here where it was a national provider, but when we asked the questions, hey, you know, you've got all this great online stuff, everything's online. You know, how does someone access it if they're blind or deaf? They actually didn't have a backup, and that's surprising. You know, we all think that nowadays someone's always going to, you know, has thought about those things, but the fact is that a lot of providers out there still haven't caught up with some of the rules that apply. Okay, the second category, and this is a little quicker here, is age discrimination. You just need to be aware that certainly to the extent that you're putting into effect, you know, something that's wellness or disease related that might impact people based on their age, that you need to be thinking about the Age Discrimination in Employment Act. We don't usually see this for the standard wellness program. You know, if your wellness program relates to, let's say, weight loss or tobacco usage, you know, let's focus on weight loss. The fact that perhaps people in their older years tend to be heavier than those in their younger years, you know, that in and of itself is not going to be treated as age discrimination. It's something that's more specific to older versus younger. And note age discrimination. For many of you, you may fall under the exemption or under the threshold of 20 or more employees. So that's not a one-size-fits-all type of requirement. COBRA. Okay, this gets us into a discussion that is going to COBRA and ERISA and some of the HIPAA information protection rules only apply if we have a health or wellness program, a wellness program or disease management program that provides medical care or is treated as a group health plan. So you're going to start hearing this concept more as I go through legal requirements. And the question of whether or not a wellness program or disease management program qualifies as a group health plan really focuses on whether or not it provides medical care. You know, if you think about it, some wellness and disease management programs simply promote a good health or healthy lifestyle. But there's others that really go beyond and provide things like, if you're providing physical exams, cholesterol screenings, flu shots. I think this is one of the most common violations, and we'll talk about this more when we do some specific examples at the end. You know, tobacco cessation counseling or prescription drugs can sometimes trigger this. Nutrition counseling even might go beyond the promoting good health and healthy lifestyles, depending on who the consulting is being provided by. And so to the extent that a wellness or disease management program provides what we call medical benefits, then it's likely to be treated as a group health plan and then will be subject to certain requirements of COBRA, and as I'm going to talk about in a few minutes, ERISA and some other HIPAA requirements. So how do you, what do you do for COBRA? You know, COBRA is going to apply if you have 20 or more employees. So once again, similar to the age discrimination rules, those of you that are smaller don't have to focus on this. But you may actually need to focus on some state mini-COBRA laws, depending on where you have locations. What's important about COBRA is just it's going to be a consideration in how you structure your wellness or disease management program. If your wellness or disease management is run as part of your medical plan, you know, you offer it to anyone who participates in your medical plan, then it's just going to sort of tag along with your medical coverage. And if someone elects COBRA, well, then they're also going to continue to be entitled to wellness and disease management offerings that you may have out there. As an alternative, you might choose not to run your wellness or disease management program through your health plan. Let's say you decide to just go out there and sort of put in place your own separate from the NCMS plan. And you're just going to, you know, kind of offer some of these incentives on the side and maybe even offer people the opportunity to get some of their services, you know, at your own office. You need to really make sure that you're talking with your experts, you know, whether it's benefits consultants, wellness and disease management consultants, your legal advisors, to make sure that you're setting it up properly. Because if your little separate wellness program actually provides this medical care, you may have to, let's say someone terminates employment with you, you may have to actually issue them a separate COBRA notice saying, hey, listen, and you can elect to continue to participate in our wellness programs after you leave. As you can imagine, that can kind of put people in a weird circumstance, especially if the employee did not leave under the greatest of situations. You know, do you really, if you're operating health fairs or you're providing some on-site wellness services to your employee population, do you really want someone coming back and showing up and saying, listen, you know, I want to get my flu shots and my, you know, my other services here on site. You know, there may be reasons that you don't want them to come back on site. So it's just something to to think about. I would say that's a big reason that a lot of people tend to operate their wellness and disease management programs as part of their health plan, so that they can just kind of tack on to COBRA compliance and, as we'll get into in a minute, ERISA compliance and HIPAA. But it does, even when it's run as part of the plan, like I said, it does mean that someone who terminates may still be able to come back and participate as part of their COBRA rights. And it can just put you in an unusual position sometimes. Okay, Pregnancy Discrimination Act. The general requirement here of the PDA is that you treat pregnancy-related conditions similar to other physical or mental health conditions. This is especially going to be important if you are putting in place some sort of wellness or disease management requirement where you're saying, listen, your total cholesterol goal is X, or I want a BMI of X, and if you achieve that, then, here's your reward that you get. Clearly, if you have a pregnant employee or pregnant family member, depending on how broad you operate your program, you're going to need to take a step back and actually offer alternatives for those individuals. That's the only way that you'll be able to comply with the Pregnancy Discrimination Act. Now, similar to some of these other rules that I brought up, if you have 15 or fewer employees, you're not subject to the Pregnancy Discrimination Act. But it still may be something that you certainly want to make sure that you're offering an alternative and taking a reasonable approach with your requirements. You don't want to have something as part of your wellness or disease management program that, contrary to the entire purpose here, you don't want to force something that is not for the best health and well-being of all of the individuals. So, it may just come down to one of the simplest approaches, maybe, waive any pregnancy-related condition if you can't find some sort of alternative that works better. Okay, I mentioned ERISA, the Employee Retirement Income Security Act, when I was talking about COBRA a minute ago. ERISA generally applies any time that the wellness program is sponsored or maintained by an employer and provides some sort of medical coverage. So going back to our COBRA discussion, you're looking at, is it just trying to promote a healthy lifestyle, or is there actually, I like to kind of think of it as, is there a poke or a prick involved? Is there a needle, some sort of test that requires a taking of blood or a bodily fluid? Those all clearly fall into medical care, and so they are going to trigger all of these, COBRA, ERISA, and HIPAA requirements. So, another area to look at is whether or not, if you're providing some sort of mental health or counseling, is it provided through some sort of licensed provider? If you've got a psychiatrist or even a licensed psychologist, those are going to also trigger medical care. It's not just limited to the physical, and think of it in a broader perspective. So if your arrangement provides medical care and is sponsored or maintained by an employer, then what does ERISA require? Well, the general rules under ERISA are that you have to have a plan document. If you think about it kind of like with your health plan, you've got an insurance policy and or a wrap document that goes with it that states all the terms and conditions. You have to have a summary plan description that goes to employees. Many people will combine these two. You have to have claims procedures, and thanks to the Affordable Care Act, we have some more detailed requirements now on claims procedures. And then if you have enough employees, and we're talking 100 or more employees, then we need to be thinking about Form 5500 annual reporting requirements. The ERISA requirements, unlike some of these COBRA rules and age discrimination and pregnancy discrimination rules, apply across the board to all employers. So, you know, no exceptions here. You may get out of some of the Form 5500 requirements depending on whether you're insured or self-insured, but ERISA is still going to apply to everyone. And for this reason, you know, a lot of people say, well, God, that's a bother, and there's a lot of different things that I don't want to have to deal with. That's the reason that for a lot of employers, they simply run their wellness program as part of their overall group health plan, you know, their general medical plan. You know, it's a lot easier than trying to jump through all these hoops separately yourself. If you just run it as part of the overall health plan, then you tack on to some of the compliance items that are already taken care of. So there's a big advantage there. And the other reason that you see a lot of people under ERISA put their wellness and disease management programs into their group health plan is that if you operated your plan separately, you know, we come up with a lot more potential issues where people can claim, hey, you know, you might have taken actions against me because I didn't participate in your program that violate ERISA. There's a section of ERISA, what we call ERISA Section 510, that prohibits employers from taking any sort of employment-related action, like terminating an employee or firing an employee who refuses to participate in a wellness or disease management program. I mean, this can apply whether your program is run as part of your health plan or not, but we see that it tends to come up more often where you operate a separate wellness or disease management program. The way that ERISA 510 works is it basically says that if you take any sort of employment action against an employee who refuses to participate, then that employee has a claim for damages and penalties under ERISA 510. And that applies not only if you're trying to penalize the employee for not participating, but also for somehow, taking steps to interfere with their rights to participate in your program. Now, there's been several court cases on this, and we can go back and forth on different ways that people have gotten around it. Some of the requirements, for instance, if there were drug testing as part of a wellness program or tobacco use testing as part of a wellness program, this could get an employer into hot water if they were making it a requirement for employment. Because think about it, if somebody failed their tobacco usage test and you fired them as a result of having failed that test, then, okay, you've taken steps to penalize someone for refusing or not achieving a goal that you set within your disease management or wellness program. Now, there's some cases that have said, we could get into all these little minor details, but where if you're doing that as part of hiring, that's not covered by these rules, but if it's while someone is employed, it is. But the end result is when you get into these sorts of issues, you want to make sure that somebody's running your plan that knows what they're doing. And when you're communicating your disease management or wellness plan and its requirements to employees, that you're always taking steps to make clear that, these are voluntary, kind of going back with that magic word that we talked about earlier, that these are voluntary programs. Somebody's employment is not supposed to be conditioned on them complying with, with achieving certain goals. We'll talk in just a minute here about some other issues that can arise if you start requiring that someone, for instance, be a non-smoker in order to be employed. We have state laws, and in particular, North Carolina has a state law that we'll talk about that would prohibit you from actually discriminating against someone for what they do in their off-duty hours. Okay, the last big law, there's a few others that we'll kind of touch on, is the Health Insurance Portability and Accountability Act, HIPAA. We all deal with HIPAA on the privacy side. It's kind of changed the way many people do things and check in patients, dealing with privacy notices and whether or not your electronic systems are compliant with HIPAA security requirements. All of that type of stuff has sort of invaded our lives with HIPAA. And it provides certainly some good protections there. To the extent that your wellness or disease management program provides medical care and qualifies, kind of as I talked about earlier, as a group health plan, you're going to need to think about these privacy and security rules. So whoever you're having operate your plan and whatever you're doing in storing records and sharing records, you need to think about and make sure that, with your vendor, do you have a business associate agreement in place like HIPAA requires? Make sure that that's checked off. A lot of people kind of think of wellness separate and apart from their health plan, and like I said, that's fine. It depends on how you're structuring it, but it still might have its own HIPAA requirements that you need to be focused on. But the biggest issue with HIPAA, and the biggest reason that we need to focus on it, is that there are HIPAA non-discrimination rules out there. And those basically require that if a program mandates that you satisfy a standard related to some sort of health factor, then you have to take steps to limit how your awards are being handled. So there's certainly programs that are exempt from these HIPAA non-discrimination rules, such as minor sort of wellness, good health programs like a standalone program where you pay health club dues, or you award T-shirts to somebody that walks certain miles, or you only provide general educational health information. But what we need to focus on is the programs where you actually give, the carrot or the stick. You impose some different co-insurance, some different deductible or co-payment, or require some sort of different contribution level based on whether or not someone either satisfies or meets some health factor. And a health factor for this purpose is something that includes someone's health status, maybe a medical condition like a physical or mental illness. Claims experience would be a health factor. Receipt of health care, someone's medical history that you're asking about, genetic information, and we'll talk in a minute about how genetic information can raise a lot of different issues. Some being able to provide evidence of insurability, whether or not they have a disability. All of those are health factors that can trigger these HIPAA rules. But the biggest focus is, okay, most of your wellness and disease management programs are going to involve health factors. So how do you comply with HIPAA's non-discrimination rules? Well, HIPAA's non-discrimination rules include a big exception where individuals adhere to some sort of program for health promotion or disease prevention. And that's what we want to focus on here. We want to focus on if something is provided as part of a larger plan, and it's either provided, or it's provided as a standalone plan, but its focus is health promotion or disease prevention, then we can exempt it under HIPAA's non-discrimination rules by satisfying certain requirements. And HIPAA breaks these into what they call participatory programs and health contingent programs. I'm not going to go into, many of you will be thankful, exhaustive detail on what all of these requirements are, but just know the basic breakdown is we look at, are you requiring that people merely participate in a program? You know, you don't provide a reward or condition eligibility for a reward on someone satisfying a certain health factor. If you are running that type of program, it's called a participatory wellness program, then you can be exempted under these or compliant with these HIPAA rules if you simply just offer it to all similarly situated individuals. So examples of this might be you provide the cost of membership at a fitness center, or you run a diagnostic testing program that rewards people for participating, but it doesn't base the reward on what the outcome is. Same with a smoking cessation program where people just need to sign up. You're not actually measuring or gauging their reward on whether or not they actually quit smoking. Or you ask an employee to complete a health risk assessment, but you don't actually require any further action like educational programs or counseling based on what their response is. On the flip side, so those are easy, offer them to all similarly situated individuals. On the flip side, there are these health contingent programs, and there's a big trend nowadays definitely to run to more of a health contingent type of program. People want to see results. And so if you require that someone satisfy some sort of health factor to either save on premiums or get some sort of reward, that's what's called a health contingent wellness program. And that has to satisfy a whole bunch of different requirements. There's 5 basic requirements. Generally, you have to offer people the opportunity to get the reward or opt into getting the reward at least once a year. The reward is limited to 30% of the cost of someone's health coverage. So in other words, if you're offering a premium reduction, 30% would be your limit. Although there's a 50%, you have the ability to go up to 50% if we're talking about tobacco-related standards. The program has to be reasonably designed to promote health. There has to be uniform availability and kind of touching on the subject of these ADA and pregnancy discrimination alternatives. Similarly, under HIPAA, you have to offer reasonable alternative standards. What's important about these reasonable alternative standard requirements is if you are operating a wellness or disease management program and someone comes to you, let's say you're just signed up in NCMS's plan and you decide to add some of these wellness programs. If someone approaches you and says that, you know, you're requiring that we achieve this certain cholesterol level or that we, you know, have a BMI of a certain level or that we do something that actually qualifies us for this reduction. If they come to you and they say, you know, I'm not able to do that for a disability-related purpose, you know, as we talked about earlier, pregnancy-related, just in general, they say, I cannot do that, then you need to make sure that you are considering whether or not you're required to offer them an alternative. And if you're in NCMS's plan, that's when you would definitely want to reach out and see what alternatives are available and how the specific rules work. If you're operating your own program, you know, that's the step where, okay, you need to be reaching out to get more expert advice to make sure that you're not running afoul of the HIPAA rules. Now, HIPAA, you know, I've talked earlier about some of these rules have exceptions for smaller employers. No exceptions here. Everyone is subject to the HIPAA rules. Remember, privacy and security, in most cases, anytime you're involving some sort of medical care are going to apply, so you need to be focused on whether or not business associate agreements are needed with any of your vendors. The Mental Health Parity Act, we won't go into detail here on this, but basically mental and substance abuse services have to be treated the same as major medical services. So you need to keep this in mind when you're offering alternative standards and setting up your wellness program, because to the extent that you are treating people differently or your achievement requirements differently depending on physical versus mental standards, that may put you at risk of violating the Mental Health Parity Act. And then finally, the Genetic Information Non-Discrimination Act, GINA. If your wellness qualifies as a group health plan, so kind of the same issue we dealt with as COBRA and ERISA, then GINA is going to prohibit you from adjusting premiums based on genetic info, or most importantly, collecting genetic information prior to or in connection with enrollment, so someone's family medical history. You'll notice that a lot of the questionnaires that insurance companies and plans and even wellness providers used to send out asked a lot more about what type of medical history your parents had, grandparents, what runs in the family. And for a lot of you that are physicians, that's on your intake forms with your patients. But in the employment context and in the employee benefit plan context, GINA makes that a problem. So you need to make sure that you're aware if you are putting together your own questionnaire forms and asking for information, or you have, let's say, an insurance broker that comes to you or a wellness provider and asks you to obtain information that is genetic in nature, then you need to kind of push back and make sure that you are complying with the GINA requirements. Now, genetic information for this purpose is going to be anything like, as I said earlier, the family medical history. It could be something like not just what you yourself have suffered from as far as illnesses, but somebody who is a blood relative. Are they, have they suffered from cancer? Is there some sort of history of disease within a family? Those are the types of things that trigger GINA requirements. GINA, as with some of our earlier laws, does have a minimum threshold of employees. That is 15. So for those of you that are smaller operations, you're not going to need to worry about GINA, but think of it as you grow in size. Okay, now let's talk about a few specific examples and kind of things that you need to be considering as you're putting in place different wellness or disease management programs. So the first would be flu shots. I think as I mentioned at the very beginning, flu shots are probably the most common wellness program adopted by employers. I would venture to say that most employers don't even realize that they offer a wellness program in the guise of their flu shots. But technically, flu shots are treated as medical care. Remember where I was talking about pokes and pricks? Anytime that you are using a needle on someone or drawing blood or testing urine, any type of bodily fluid, you've got medical care involved. So flu shots do raise the issues. Are you offering them to all of your employees, or are you offering them to your medical plan participants? This can make a difference on what the requirements are that apply. For some employers, the way they will structure it is that those employees who participate in our medical plan will have their flu shots fully covered, and they roll those flu shots, in a sense, into and as part of the medical plan. That way, ERISA, COBRA, HIPAA, all these things are complied with. But they may feel like they want to offer flu shots on a broader scale just for convenience to employees. What many will do in that case is simply offer flu shots the availability without really otherwise promoting them. Hey, if you're not in our medical plan, you can still sign up to the extent there's space available and pay a flat fee that, you know, whoever the flu shot provider is will charge. That's one way that we see a lot of employers try to kind of skirt these requirements and structure their programs. On-site health fairs. You know, employer sponsors an on-site health fair. You offer different screenings, information, and educational programs. Employees are not required to participate, but if they do, they receive an annual credit towards premiums. Well, this is, when we were talking about HIPAA requirements, participation-based. So you are fine offering an annual credit for participation as long as you offer this program to all similarly situated employees. You're doing great. It does involve various screenings, assuming that those screenings likely qualify as medical care. What you need to consider is, okay, am I doing this through my health plan, or am I offering it to all employees? And if I am offering it sort of separately, you know, what steps has my vendor taken to comply with the legal requirements? You know, make sure that you've got some agreement in place with them and that they've signed off saying, you know, listen, we'll take care of the various legal requirements, and, you know, in the perfect world, we'll indemnify you, and, you know, here's what we've done to comply. Those are the types of things, if you're running a separate a program, that you need to make sure you've covered. If you're running it through NCMS's program, then that's going to be taken care of at NCMS's side, and you know, it's going to be as part of the plan and the NCMS offerings. Okay, the next one would be a weight loss program. So if you're an employer, you put in place a weight loss program and you give rewards for participating in certain activities. Well, okay, those are participation-based, but you give rewards for achieving weight loss goals, like a percentage that someone needs to lose. Now we're moving into what we talked about that is outcome-based, and you need to make sure that whatever your reward is, you know, are you giving someone a discount on their premiums? Or are you giving them some sort of cash spending account, let's say a credit to their HSA or HRA that they can spend? Well, you need to figure out, you know, is that complying with the 30% requirement we talked about earlier? Or, you know, can you go as high as, well, you definitely can't go any higher than that, but is it complying with those requirements? Also consider the ADA alternatives, Americans with Disabilities Act alternatives, because you need to be focused on whether or not someone has, you know, there may be people with doctor's notes that say it is not safe for them to enter into some sort of weight loss program of the type that you're offering. You just need to be ready for people to come forward. You don't have to advertise exactly what the alternatives are that you're going to offer. But when someone comes to you, you have to be able to provide them a number to call or some description from your end of what the other ways are that they can, you know, that they can get the reward without having to go through the program. Finally, we have smoking cessation programs. We talked a bunch about those earlier, but you know, if you're going to charge a higher premium than non-smokers, smokers a higher premium than non-smokers, you know, that's certainly something you can do. As the Affordable Care Act actually made that even easier. You can go up to 50%, but you know, you need to make sure that that's being properly calculated. There are specific exemptions under, well, let me back up for a minute. As I mentioned earlier, certain states have requirements or prohibitions on having tobacco-related penalties. North Carolina is one of those states. So North Carolina says that an employer may not discriminate against smokers or tobacco use, you know, off-duty or outside of the workplace. However, an employer can charge different insurance premiums if a notice is provided and if the employer still provides an equal contribution for all employees towards the medical program. So, keep that in the back of your mind. If smoking cessation or tobacco usage is a hot button item for you and is part of your wellness program, you just need to make sure that when you're applying some of these premium credits and operating your program that, you're providing the proper notice, that you're, calculating contributions properly. And that's where, if you're going to do this, either make sure that you're going through, for instance, NCMS's program, or that if you want to do a program separately yourself, that you are actually, working with somebody that knows these rules, whether there's a lot of good vendors out there that offer programs, but at the same time, there's also a lot of good legal counsel that can help you design the right one for you. But you just need to be working with somebody that can help there. Jason, are you on the line?
I certainly am.
Let's talk about the sample communication that we have on the slide here.
Sure. Yeah, this is just a sample communication that, after we talk about all the requirements and different things, the 5 considerations when you start an outcomes-based wellness program or a participation wellness program, this is a sample communication that you can use that really fits into those guidelines. And of course, every practice is very unique and specific, so I encourage you to connect with me and consider all the different requirements that Ann talked about to really come up with a communication that outlines your wellness program along with me. So that's really all I wanted to say about that sample communication.
And I think that's what's really important, as we see with a lot of these different rules that impact wellness programs. The cost savings can be huge, both from just a monetary perspective as far as what your overall health costs are, but also just from a happiness and attendance perspective in the workplace. The wellness programs, as Jason talked about at the beginning, have been shown to drastically increase or address attendance problems in some workplaces and really result in sort of a happier employee, not sort of, but a happier employee overall. So it can be beneficial. The point here is of today's presentation is not to scare you off, but to at least make you familiar enough with a few of these rules that things will pop into your mind as people come to you with questions on what they can or can't do, or concerns about what they're being asked to do. It's all workable. It's just that sometimes you don't know what you don't know. So at least if you've heard some of this and are able to ask the questions or know when to reach out to Jason and other folks at NCMS, I think that's kind of half the battle with compliance. You'll see a link to the NCMS, the portion of the NCMS website on wellness. So I encourage everyone to certainly go visit that and certainly reach out to, if you haven't spoken with, if you use some outside vendor for a separate program, and any of this, caused concern or raises a question for you about whether something's addressed, certainly reach out to them. And, most providers will be able to, most vendors will be able to, provide you lots of information that should show how they're complying with these requirements. So at that point, I think we're open for questions. I know we're right up at an hour, so we can certainly, those that want to stay on, we can take a few questions here.
And as a reminder, if you would like to ask a question at this time, simply type your question into the Q&A panel on the right-hand side of your screen. Select Send to All Panelists from the drop-down. Click the Send button and your question will be into queue. We will also be initiating the file transfer here shortly. You will see a file transfer window appear on your screen. To download the file, click on the file name and then the download button. Again, that file transfer will be occurring shortly. Just keep an eye out for the pop-up window.
Hey, Ann, this is Gary, and this also maybe for Jason, too. Talking about smoking cessation, we have had practices that some will have employees sign an attestation to say that an employee is a smoker or non-smoker, whereas other practices may be looking for something more more specific, say the swab, taking a swab. Is there any difference between the two that any considerations a practice should make when debating whether to simply do an attestation versus going the full route of doing like a tobacco swab?
So I can take that question, Gary. Typically when I consult on tobacco affidavits versus the swab or any kind of cotinine test, I always encourage the practices that can maybe start with an affidavit because it kind of goes a little less lightly and kind of takes the self-reported part of the whole entire practice. And then maybe in a couple years or 2 years after the self-reported affidavit test, move into the testing, maybe aligned with a practice's biometric screening or sort of open enrollment. Ann, do you have anything else to add about that?
Yeah, I've found exactly the same thing that Jason's talking about. And this sort of goes almost to the non-legal side of things, but I have seen clients where they have put in place the swab type of testing immediately, and you really create a lot more pushback. I think that it is something that and some people might say, well, that's well deserved, but it, people just don't tend to deal well with change. But I think especially when it comes to the smoking cessation, it's better to ease into it. Even from a legal perspective, it's going to appear more of a reasonable program. And remember that you could still have people who come forward and need alternatives to some of the smoking cessation. If you're requiring that they take the test, there may be people that, believe it or not, will show up with a doctor's note and reasons that they need alternatives provided to them. So you just need to be thinking through how you'll deal with that.
That makes sense. Thank you. We have another question here from an attendee. The question is this: we offer a $15 incentive for employees who complete a preventive care exam during the plan year. Is this okay?
Yes, most definitely. There is, that is, even though that involves an actual exam, it is still simply a participatory program. You are just saying show up for a preventive care exam. I'm assuming here, but you're basically rewarding them for getting a checkup, not for actually achieving a certain result during that exam. And so that is, it's not outcomes based, and so you don't have to worry about certain limits on the dollar amount that you can reward to people. Now, there's also some question whether you do it through your plan or whether you do it separately as an employer and simply give $15 to someone if they go and get a preventive care checkup. There are actually ways that offering the $15 and having them just go get a preventive care checkup, there's ways that might actually just be exempted and not even be considered a wellness or disease management program that's subject to some of these laws we're talking about here. So, I don't have many concerns on that end. Jason?
Yeah, I just wanted to add one thing too, Ann, to kind of complement what you talked about. Talking about the 30% limit on the participation-based program, you might want to consider, overall engagement into the compliance with preventative care annual exams. Is $15, enough? Is that a big enough incentive to really push people to get their screening? So even though that is definitely consistent with the legal requirements, take a step back and say, is this really pushing people to do something?
Oh, that's good. That's a very good point.
Yeah.
Hey, Jason, you mentioned that 30% incentive. So that's a good segue into the next question. The question is, how do you calculate the 30% limit on premium discount? Is it 30% of the total monthly premium or 30% of the employee portion, meaning what the employee would pay for their health insurance?
Yeah. Oh boy, you definitely open a can of worms. We could do an hour alone on how you calculate these discounts, just because some of it depends on. And Jason, jump in if you have some input on this as well. But the reason I say this is, yes, if it's just an employee that this is available to, then we're talking about the employee-only premium. To the extent that that employee then enrolls in a family coverage, we actually have to sort of back into and still just give him, we have to calculate it based on the employee-only premium. Now, if you offer a incentive or, reward to not only the employee, but also, let's say, the employee's spouse who participates in certain health risk assessments or whatever you might be requiring, then there's ways that you can apply it on, a larger scale to a family coverage, but it starts getting in very detailed and into the minutia here.
And just to make that clear, is it the employee-only coverage that the practice covers, or is it the portion that the employee pays? What do you base that percentage off of?
I believe that it is on we can actually back into the full coverage cost, but there's still a question also, and don't forget this, about whether or not it is a carrot or a stick, and whether if you tack on an additional charge versus whether you are deducting from the total premium, that's going to make a difference when we calculate these percentages as well. As I said, it can get into a very complicated sort of discussion about, how, if you have an employee plus one premium, then what do we do there? We have to back into, how many dependents are participating, whether an employee and his spouse are eligible, and but it is, like I said, it is based on the total cost of the employee-only coverage.
Right. I think at the end of the day, too, was just consider to kind of stay well below that threshold of 30% or 50%, and then also make it sort of a meaningful incentive that it is accomplishing what you want it to accomplish.
Correct.
Okay. And to the person who asked that question, if there's a specific structure or dollar amounts, premium amounts that you would like to maybe have Jason, perhaps even Ann, take a look at, you can contact Jason following the presentation. We can talk more specifically about the dollars involved in your situation.
Right.
That is the last question. I know we went over by a little bit, but I appreciate everybody's patience. Ann, thank you very much for your insight and the good knowledge that you shared. Jason, I appreciate you putting it in the context of the Medical Society Plan. I would encourage anyone that's on the call that if you've not spoken with Jason before about developing a health promotion strategy for your practice, I encourage you to do so. Jason has a lot of tools in his toolbox that he can bring to bear to improve the health of your employees, and I know that he is motivated and anxious to do that. So please reach out to Jason, and thank you again for participating today. Thank you, everybody.
Thank you again for joining us today. This does conclude today's conference, and you may now disconnect.